Good morning. You may be seated. Thank you. I'll learn I'm 6:30. Good morning. Court is calling S-1-SC-40328 State versus Trujillo. Appellant, you have 23 minutes. You can enter your appearance and begin, please.
Your Honors, Nina Lalovic on behalf of Judah Trujillo met Samuel Rivera on Grand Race. The two of them agreed to meet in the middle of the night in the park for sexual encounter. Nobody knows what happened during that encounter, other than it ended with Judah shooting and killing Samuel. Despite the state providing no evidence of deliberate intention, the jury found Judah guilty of first-degree murder. The jury had been asked to decide between first degree, second degree, and voluntary. And while it was deliberating, it apparently became confused, and it sent a note. And the note quoted the language of the first-degree murder instruction, the portion that read, "A mere unconsidered and rash impulse, even though it includes an intent to kill, is not a deliberate intention to kill." The jury asked the court to clarify, saying that it found that language contradictory, and it wanted the court to provide an example difference between rash and impulsive, intentional killing, and deliberate intention. The court sent the jury back, telling them to rely on the instructions that it already had. And as we know, those instructions included the motive instruction at issue in this case. And that instruction told the jury that the state did not have to prove motive.
Did your client ask for that instruction?
The record does not include who.
Don't dodge it. What does the record show?
The record shows nothing, apparently. And I contacted the district court and they had destroyed the jury instructions, and the jury instruction conference that occurred in this case. Basically what the judge said was, I don't want to waste time. I don't want to deal with duplicates. You all meet.
Bring me instructions, right?
And go over the instructions that the two of you have come up with and pull the duplicates and present me with a final packet.
And did they do that?
They did do that.
And was that instruction in there?
That instruction was in there.
So is it fair to say your client, and tell me, it may not be, but is it fair to assume, given that record, that your client asked for that instruction?
No.
No, why not?
Because there's really no evidence at all of who requested the instruction. We do have, as the state pointed out in
Did that instruction help your client or help the state?
Is there anything in the record that shows your client objected to the instruction?
No, neither party objected. Once the jury instruction packet was given to the judge, she read through all of the instructions and nobody objected to any of them.
What was the prejudice of that instruction?
The prejudice of that instruction was that the state was at least partially relieved of its burden. Most lay people probably don't understand the difference between motive and intent. And so by being told that the state didn't have to prove motive, when you have a jury that's struggling with the difference between a rash and impulsive intentional act and an act done with deliberate intention, that makes it easier for the jury to then go to first-degree murder, because they're now told you don't have to find motive, which means possibly in a jury's mind, you don't need to really think about how the careful deliberation that went into this killing and whether that occurred.
What's the state's best evidence to your mind of deliberation? I get that you disagree with much of it, but what do you think their best evidence is?
Of deliberation.
Mm-hmm.
I mean, really, there's no evidence of deliberation. What the state relied on in closing, in addition to reminding the jury that it did not need to prove motive, it really focused on the fact that Judah had gone to this encounter with a gun. But as our case law tells us, going to an encounter with a gun alone is not enough for first-degree murder. There have to be other indications of deliberation, I should have said. There have to be other indications of deliberation.
They do argue that what I would call after act evidence, or on the issue of deliberation. What is your response to that?
Well, multiple cases have talked about after the act evidence, and I don't have a cite off the top of my head, although I believe it's in my briefs, that after the act evidence goes to guilt, but not necessarily to the level of homicide that was committed here.
I'm curious about that. Does the defendant in some of these, like fleeing, the defendant knows what they're charged with? I'll try and frame this question well, because I've thought about it. I'm not sure I'm going to, but is it just consciousness of guilt that I committed an act, or is it consciousness of guilt that I committed the crime that is charged under case law? That it was a murder or that it was a deliberate murder?
I believe that it's consciousness of committing an act the defendant believes to be wrong. And that I doubt there's any defendant out there who thinks about what level of homicide they've committed at the moment that they run home to their mom, or get rid of the gun. Those were all things that Judah did here, basically to cover up that he had done something, but we don't know what that something is. And after the fact evidence, this court has stated it in multiple cases. I know at least one is the early 1990s State versus Garcia. The court talked about after the fact evidence. And I know there are others, but I'm not.
So the state in their closing focuses on taking the loaded gun to the park, but at the time of directed verdict, did they focus on lack of DNA evidence as well? And and if so, what is your response to lack of DNA evidence being unsupportive from your perspective of deliberation?
Well, the DNA expert basically provided nothing useful to the state. There was no DNA evidence, but what the DNA expert testified to is that there was other DNA found other than I think they said other than Samuel Cordero's, but that there wasn't enough for them to test it and determine whose it was. And then on a number of items, there was no DNA whatsoever.
Doesn't the lack of DNA suggest that perhaps there wasn't the battle that the defendant describes, the grabbing the arm, the pulling them along, because with contact like that, we kind of expect DNA.
Except that the DNA expert said the opposite. She said that there's no way to know that there can be contact that where DNA doesn't show up, or no contact, like, well, no contact, but there are basically a lack of DNA doesn't tell you anything about whether there was contact or not. And we do know from the state's collection of evidence that what they were looking for and collected of what Judah was wearing that night was a sweatshirt. So if Samuel grabbed his arm, he would have grabbed his shirt. And so there wouldn't necessarily be.
Counsel, it seems to me that the evidence does demonstrate an intentional killing. And I don't think you contest that. It seems to me also, maybe this is more a philosophical point, I don't know, but to be intentional, there has to be some deliberation. I mean, you have to think about what you're doing for it to be intentional. And what's the difference between that and deliberate intent for first-degree murder? if any?
Well, what the cases tell us is that for first degree deliberate intention murder, the defendant has to have carefully weighed the, I guess, the pros and cons of what he's doing and carefully thought about what he was going to do. And that can happen in an instant, but where it does, as this court said in State versus Tafoya, if it happens in an instant, there has to be other evidence of deliberation. And as far as second degree murder, intentional killing, that is the doing of an intentional act without regard for human life, basically without regard for the consequences. And so there's clearly an intentional act either way. But one is a contemplation of the desire to kill for whatever reason, and the other one is an act of reckless act, basically.
Thank you.
Counsel, I want to ask you a question about what we should do with this case if we agree with you. If we agree that there was insufficient evidence of deliberate intent, can we direct a verdict for second degree murder rather than require a new trial?
If this court rules on sufficiency alone, it can pursuant to the direct remand rule, find second degree murder and direct the district court to enter that conviction. However, because Judah is arguing that the motive instruction played a role and had an impact in this jury's decision, Judah is arguing that he should go down for a new trial on both second degree murder and voluntary and let the jury decide in a case where no do not give instructions are provided to the jury.
So we would only remand for a new trial if we found an error in the instruction.
Correct.
What about the tampering? How does that affect tampering?
Tampering, because the jury found tampering of first degree murder, if this court finds that there's no first degree murder or sends it back for a new trial based on the motive instruction, the tampering would also need to be.
What about sufficiency?
What if it was just on sufficiency that we agreed with you?
Well,
Can we still direct a verdict on
On-
second degree?
on second degree tampering,
Because it's the same level, right? It's still third degree felony, I believe.
well, it was a special verdict. But under Tafoya, I think this court could enter a verdict. Because in Tafoya, there were two Tafoya cases. There was the one where this court found it wasn't first degree murder. And then after he went down to be resentenced on second, the court entered a firearm enhancement, but the jury had never made a finding on firearm enhancement for second degree murder. And then, so he appealed that, and this court, I believe it was this court or the Court of Appeals, found that there didn't need to be a finding because it was given that there was a gun involved. So I feel like with similar reasoning, this court could enter a verdict. If this court decided to rule on sufficiency alone and not on the instructional error, the court could direct a verdict, direct remand to second degree murder and then also to second degree tampering.
But I thought you said, I thought I heard you say earlier that with regard to second degree murder, intent is a jury question.
Yes.
So if intent is a jury question is with regard to second degree murder, it would also be a jury question with regard to tampering with evidence to hide evidence of a second degree murder. What am I missing?
Well, as far as the murder, I think the direct remand rule answers that question. As far as the tampering, I'm honestly not entirely clear on that, and I'm just thinking, because the second Tafoya was my case, and I remember arguing this, that similar reasoning might be used, where even where a jury hasn't made a finding, this court allowed the firearm enhancement.
So, I mean, if there was a struggle related to the shooting, and if there's that struggle and there's that fear still there and he's running away and throws the gun, I mean, it's not necessarily to hide evidence of a homicide, given the disputed fact as to intent. I think I'm missing something, if I understand your argument.
Well, and I may be misunderstanding the question. I mean, Judah's argument, excuse me, is that the careful deliberation required for first-degree murder is not proven by the state. And so he asks this court to either grant a new trial on all of the counts based on the jury instruction error, or under the direct remand rule, remand to.
But you only do direct remand. The direct remand rule, as I understand it, only applies if there's no disputed issues of fact or issues to be tried.
Well, and obviously, if there's certainly a view of the evidence that there was sufficient provocation here and that this was voluntary manslaughter. And if this court were to find insufficient evidence of first-degree murder, but not decide which, basically leave it to a jury to decide what's left.
Finder of fact, to
Yes.
decide which level.
Yes.
So that's what I'm, so the same thing would apply to the tampering with evidence. I don't know how you can
Yes.
direct remand to say on direct remand or direct that it's remanded for entry of a verdict of guilty on tampering with evidence for second-degree murder. I just don't see that.
Well, I think it only can occur if this court directs,
There's no disputed issues of fact.
which would be up to this court to decide. So.
If there's issues of fact, there's no direct remand.
Correct.
You don't have to agree with any of us on this, by the way. I think you're struggling because I'm not sure you actually agree that this shouldn't be a new trial
Oh, no, I believe this should be a new trial.
as opposed to direct in
Yes.
exercise. Okay, that's why I think
On the
it's,
homicide.
yeah, I
but
think
she's-
that's the disconnect and that's what's so hard.
I think the disconnect is with regard to the tampering charge.
Well, if,
You think the new trial based on the motive instruction, not on sufficiency alone. If we only agree with you on sufficiency, then you agree it should be a direct remand on second degree.
I agree that this court can enter direct remand on second-degree murder. The tampering, I feel like, is a closer question. But under this court's previous reasoning, I think it could be done.
So you're asking us to make a decision that the evidence does not support voluntary manslaughter as a matter of law, given your client's testimony.
No, Your Honor,
That's the only way we can enter a directed verdict for second-degree murder.
well, Judah's position is that this is an open question, that there is a view of the evidence that we don't know we just don't know what happened. And so another jury might listen to Judah's explanation and believe that there was sufficient provocation and find voluntary manslaughter, which is why Judah would prefer that this go down for a new trial and let the jury decide between second and voluntary.
Regardless if it's insufficient evidence or on the basis of lack of motive structure.
Yes,
But you agree the defendant took the stand, said he shot him.
yeah, oh,
Agree with
yes,
that?
yes. There's no
Is that
doubt.
undisputed?
That is undisputed.
Okay.
Though he did give an explanation. He provided an explanation of what happened, that he was afraid he was going to be raped and
Sure.
that he was punched and stumbled. And so there may be a finding of sufficient provocation.
Did not get the provocations.
Yes.
The jury didn't find it.
The jury
Right.
did not find it. That's, yes, there was no finding.
A little time left.
Um,
I want to clarify something on the motive question, though. I'm not quite understanding. I understand your argument with motive in first degree. You think it's error that causes vacating that. And your explanation to us is it confused them with regard to their burden of proof on the deliberation, I think was your argument. I'm not understanding how you're carrying that to second degree. Because that wouldn't be required.
well,
Why would if there were an error in the motive instruction, assuming that is true, why would it defeat the second degree?
it wouldn't, Your Honor. It's, the problem with the motive instruction is that I believe it, in this particular case, it confused the jury
Okay.
with regard to the intent required for first degree murder, not second. But, well, no, because motive is just less relevant to second degree. It's more of a first degree consideration.
Anything else?
No, the court has nothing further.
All right, thank you, counsel. You have 7 minutes of rebuttal. For the state, 15 minutes.
Thank you, Chief Justice. Justices, may it please the court. This appeal consists of 4 issues. The first is whether there's sufficient evidence of first-degree murder, to which the state would argue there was. The second issue is whether the district court erred in giving the motive instruction, an instruction which the state would contend defendant stipulated to, if not proffered. And more importantly, which did not form an essential element of first-degree murder, which was properly instructed, second-degree murder, which was properly instructed, or voluntary manslaughter, which was also properly instructed. And third, following only if this court were to conclude that first-degree murder was not proven, defendant contends he should be retried as to the level of tampering with evidence. The state would first argue that there's sufficient evidence of first-degree murder, so that should not be the result. However, in the alternative, the state would argue that that can be remanded to the district court to enter the proper level related to tampering with evidence. And the reason for that is, in addition to the step-down instructions which were given as to the level of murder, there was also special verdict forms and tiered instruction as to the tampering with evidence crime as well. And so because the jury had all of that, we believe the direct remand rule would also apply to the tampering with evidence. The fourth issue, I just want to, so it's on the record, the state did concede that the defendant should have received time, his pre-sentence confinement time. And so because of that, even if this court were to agree with the state and affirm defendant's conviction, which is what we would ask you to do, we do agree that the case does need to be remanded so that defendant can receive credit for that pre-sentence confinement time.
I want to dig right into the sufficiency because it appears to me that in presenting the case to the court, both at the trial court and now, that the entire tactic was he's a bad guy and he's a liar. And that's really what comes through when you're looking at the record here. And that you are taking all of these disparate facts and trying to conglomerate them into something that looks like deliberation, but it neither walks like a duck or talks like a duck. So I need you to get really, really specific, really fast on what you think supports deliberation here. And then we're going to talk about all of it.
All right. Your Honor, I would point this court to State v. Chavez. It came out last year. The site for that is 2024 S-1-SC-40328. In that case, this court looked at a similar issue, first-degree murder, where the evidence was based on circumstantial evidence, which is what we have here. And the court determined that what you look at is this totality of the circumstances, the woven tapestry of all the circumstantial evidence placed before the court, placed before the jury without searching for inferences supporting a contrary verdict or reweighing evidence, because that type of analysis would substitute the appellate court's judgment for that of the jury. And so
that, look at this, that requires something in this universe, this totality of circumstances, to suggest deliberation. It can't just be he's a bad guy. So I need you to get into the facts. Tell me what this totality is. It's not just, it can't be things that don't give some indicia of deliberation that then equals deliberation. Three pineapples does not equal a watermelon because of the totality of the circumstances. And that's really what it seems to me that's being argued.
the state would respectfully disagree with the characterization that Your Honor makes as to there being no evidence of this deliberation. We believe, yes.
Point me to it.
Going to.
Point me to it.
Justice, very similar to the discussion that happened in Chavez. We look to defendant's actions before the killing. We look to defendant's actions there.
Specifics.
All right. In bucket one, before the murder, let's start there.
Thank you.
Defendant usually took a weapon to these sexual encounters. He always took a knife before, every single time, every single encounter. Here we have a change of course. It's unique. Defendant decided this time he was going to take a gun. Not only did he take the gun, Your Honor, but he retrieved the gun. He took steps to Google how to unlock the gun. He unlocked the gun. The gun was not loaded. He had to load the gun. In addition to that, he had to chamber a round in the gun in order to make it lethal. So even at this stage, Your Honor, what we have is we know he's leaving this house, if not with the intention necessarily to kill. Let's just give the defendant the benefit of the doubt. He's leaving the house with that being an option of killing somebody.
But doesn't our case law say, and it also takes me to like a hypothetical question.
Sure.
But our case law says you have to have more than taking a gun to whatever event you're going to. It takes more than that to establish deliberation. And that's because otherwise we would be holding support that anybody who takes a loaded weapon with them anywhere has deliberated about killing whoever their specific target. I mean, it would become this overly generalized rule.
Certainly, Your Honor. And I think defendants pointed you to case law. I think the state or the defendant points to Adonis, where the defendant left with the gun, and that wasn't enough. Now, I'll differentiate that case to say that in Adonis, he always carried a gun. He had a concealed carry license. That was something that he always had. And here I do believe it is an important fact that the jury, a reasonable juror, could have used to reach deliberation, and that this time defendant made a different choice and took a gun. But setting that aside, that's not the only evidence, Your Honor. Additionally, defendant, and this is again taking defendant's testimony and interacting with that. Defendant stated that he usually met his sexual encounters in a public place. There's nothing public about a park at 2 a.m. in the morning. We know that he told Samuel.
Do we know in the record that it was the defendant that initiated that location? That's not in the record, is it?
Actually, Your Honor, I believe that the location, so let me, no, but let me caveat this by saying, what the conversation that happened is that defendant told the victim he couldn't meet at his house because his mom and sister were there sleeping. And that's during his testimony on November 6th at the timestamp 10:12. So instead, I believe the way the conversation happened is that then victim suggested Rego Park because defendant had previously shared his address with him. And that was a close location. But again, this is 2 a.m. in the morning. This also is different.
Is always a public place.
I'm sorry, you're.
By definition, in our law, a park is a public place. It is not tethered to what time of day it is. It is open to.
It is open to the public, but I guess I'm saying public place in the sense that defendant has used that term, which is defendant has said his other places of rendezvous were always a mall, the Santa Fe Mall to be specific, or his grandmother's apartment where he met in one of the restrooms in like the main office building. So certainly places where people were there. It was during the day when people were there. This is also something that's now different. Now it's a park in the middle of the night. Nobody's there. In fact, the victim's car was the only car in the parking lot. And the victim wasn't found until several hours later in the 4 o'clock hour when a dog walker found him. So it's public, but in defendants, the way defendant has characterized meeting in public places, I'm using that definition, and this is different than that. And then we've already talked about how the gun was not ready to use. He did chamber a round. We know at some point he had to chamber that round in order to shoot the victim. So this is all before evidence. We then get to the park. He walks to the park. He meets the victim under the gazebo and again, I'm interacting with the defendant's testimony here, not the state's theory necessarily. Samuel suggests they go to the nearby dugouts. So even more secluded, even more dark. The defendant would testify that he became fearful for his life at this point. That testimony doesn't take into account that he's got a loaded gun in his pocket. But he testified that he was fearful for his life, that he would be raped. Defendant initially argued to the court that there was no evidence whatsoever of a struggle. Defendant later clarified and said, well, there's no evidence of a prolonged struggle. But what we have here from defendant's testimony is multiple alleged aggressions by the victim, multiple alleged parries by defendant, and defendant remains there at the park, even though he's been able to separate himself from the victim under his own testimony numerous times. He doesn't flee at any point. When he gets away the first time, he doesn't flee. When he gets away for the second time, he doesn't flee. When the victim allegedly goes for his throat, he's able to swat away this victim. And I want to highlight here that there is a size and age difference between the victim and the defendant, and that also matters. Victim here, as I think the court knows, is an older 60-year-old man. He weighs around 300 pounds. He's at least 6 feet tall. Our defendant is a juvenile. He's 15. He weighs about 150 pounds, and he's shorter. He's my height if I don't have heels on, approximately. So what we have here is a younger, lighter youth who is able to free himself multiple times, but stays in this scene, even though he has a gun in his pocket under his own testimony, and says he's fearful. Now, not you guys, I'm so sorry, this court. This court.
I like that. I like you
You
guys.
like that? I will never do it again. The court asked defense counsel some questions regarding the DNA evidence. I think it's important to know that there were 2 experts who testified as to the DNA evidence. There is the expert who testified to the evidence collected from the gun. And we know from that expert testimony that those swabs came back with no DNA that was testable or no DNA. But importantly, there was also another expert who testified as to the DNA swabs taken from the victim. And what we know is from defendant's testimony is that there were multiple instances where the victim grabbed defendant. He even hit him in the face. So if he was wearing a sweatshirt, and so maybe there's no DNA transfer because of that, he certainly made skin-to-skin contact when he punched him in the face. And yet there was no DNA of defendant found.
That particular expert did not testify, if my reading or my understanding of the record is correct. They didn't link the lack of touch DNA to an absence of altercation. The expert didn't go that far, only you go that far. And experience tells me that touch DNA doesn't always transfer in an altercation. So you're substituting a step in expert testimony that just isn't fair. So the absence of DNA evidence does not establish that there was no.
And I don't think that, I certainly am not, and I don't believe the state is trying to suggest that it establishes that there was no struggle. I think what the state is offering is that it's a reasonable inference that no altercation happened. And I think that that's a nuanced difference here. And so we know that there isn't this DNA evidence that could corroborate a struggle. And Your Honor is correct. The expert did not go as far as to say there was no struggle. And then we also, going back to just the summary of the evidence during this time period, placement of the bullet matters and goes to deliberation. And here, this is argued at the directed verdict stage. It's argued in closing. The state in closing argues that the placement of the bullet is something the jury should look to. The bullet went in the back of Mr. Cordero's head, came out from between his eyes. This placement, a reasonable juror could infer, was the product of an aimed shot at the back of victim's head. I also want to point out here that the jury had access to evidence that this court does not have, that I don't have, that nobody has. The district court allowed the defendant to demonstrate for the jury how he fell and how he shot the victim. This is something that the jury saw the defendant model, and which is not really captured well in the audio record, which is all that we have. And so fortunately, our standard of review accounts for that, because this court has a deferential standard of review as to what the jury concluded in this matter. We also know at this time that when the shot was fired, that under the state's theory or defendant's theory, defendant was standing feet to multiple feet away from the victim. We know that the victim was heading back towards the parking lot. So whatever struggle happened, it was no longer happening, and victim was leaving, and defendant was retreating, under his testimony, the opposite direction. Additionally, we know from the evidence that, and you can look to Exhibit 1 for this, Samuel could not have possibly blocked every path home for defendant. So even if the argument is he was blocking the path I came from, he didn't block every path for defendant to be able to leave the situation.
This leave the situation thing is, I'm still a little caught on this. Your brief talks about or suggests that deliberate intent can be inferred from failure to flee. There aren't many citations to support that. What is the case law that says if a individual does not flee, that goes towards deliberation?
There is no case that I found that states that precisely.
Okay.
I believe what it goes to is the jury's ability to infer properly from the facts that because he chose to stay, he chose to remain engaged. That this all was part of his thought process leading up to him shooting the victim.
So you've argued, so the state presents its case. Defendant makes a motion for a directed verdict. So at that point in time, the only evidence before the judge or the jury is the state's case in chief. You're arguing from evidence that was presented in the defendant's case. In looking at the sufficiency of the evidence and whether the state proved a prima facie case, are we limited to looking at the state's case in chief, or are we also allowed to look at the defendant's evidence?
Your Honor.
The state has the burden of proof beyond a reasonable doubt as to each and every element. So there's my question.
Sure, Your Honor. I believe that what this court is reviewing is not the district court's determination on the motion for directed verdict, but rather whether there was sufficient evidence as determined by the jury. And so I think because the jury had both the state's evidence and also defendant's testimony, I believe it would be proper under the issue here before this court that you look at the totality of the evidence, the totality of the circumstances, which includes defendant's testimony.
So why provide for a motion for directed verdict? What function does that serve?
And Your Honor, I think that's a good point.
Serves nothing.
That no issue has been brought to this court's attention that motion was improperly denied. So to the extent that that is an argument defendant could have made, it's not an argument that they brought before this court, that they're arguing this totality of the evidence to this court. So I think we have to look at that for this case. So then going back to the evidence, Your Honors, we also have additional missing evidence, missing in the sense that there is no direct testimony on the fact, but there is other evidence which was testified to and be linked to it. So let me be specific because I know that was super vague. What's missing from defendant's rendition of the facts is that the gun he had with him that night was a Smith & Wesson 9mm Luger. He testified he shot it, and this is his testimony, right by his ear. And actually, pay no mind to my gesticulating. I actually don't know how he demonstrated it. But he testified he shot it over his shoulder. Presumably, the gun is right by his ear. We know from the testimony of the ballistics expert who testified that when they fire the same or similar weapons in the lab to test bullet casings and to match weapons, that they have to wear ear protection in order to prevent the loud sound of the gun going off from affecting their hearing. Here, under defendant's storyline, he shot this gun right by his ear, but there's no testimony of it being loud, of his hearing hurting, of anything to that regard. And you can compare that, I think, reasonably with the testimony of the ballistics expert to arrive at whether or not defendant's rendition of the facts is reasonable in light of the evidence.
But that can bear two ways. And I've thought about this. The jury didn't seem to believe, at least it was for whatever reason he took the stand, but this was provocation or self-defense. We can accept that, can't we, without finding there was sufficient evidence for deliberation. So the jury, in your recitation of facts is correct, and the jury just didn't buy, or maybe the judge didn't, on provocation or self-defense. But does that automatically exclude the possibility that there wasn't sufficient evidence for deliberation?
I don't believe that fact necessarily goes to deliberation, Your Honor, but I think it's an important fact when some of the questions that this court has had this morning go to the direct remand rule and whether or not we can enter verdict as to second-degree murder. And I think that it would go to that argument, supporting the idea, and the state would ask the court that if you don't agree that there was sufficient evidence of first-degree murder, that the proper course of action at that point would be to remand the case for resentencing of second-degree murder. In this case, and I'll just sort of caveat there real quick, the the jury did receive all of the proper step-down instructions for first, second, and voluntary manslaughter. So under our case law, it could be proper for this court to remand for entry of second-degree murder.
So, but the instructions say you consider first-degree murder first. And only if you disagree as to first-degree murder do you go to the step down. That's the way I understand it was structured. So they never got to sufficient provocation.
So, Your Honor, under this state's precedent, in State v. Haney and in State v. Villa, State v. Haney's 1994 NMSC 110, State v. Villa 2004 NMSC 031, this court has stated that appellate courts have the authority to remand a case for entry of judgment on the lesser included offense and resentencing rather than a retrial when the evidence does not support the offense for which the defendant was convicted, but does support a lesser included offense. And that's
But that's only if the facts are undisputed. If there's facts for a jury to decide, you can't remand for entry of a verdict. That makes this court a jury.
Your Honor, in State v. Villa, there was a
Stand via. And in that case, the facts were undisputed. There's another later case involving the EPA, the state EPA, where the Court of Appeals invoked the rule and the Supreme Court chastised the court saying there was issues of fact here to be decided.
I think here, Your Honor, there is agreement that the defendant killed Samuel Cordero. And the question is whether
Why?
the question is whether or not he had deliberate intent. And so here, to the extent that this case doesn't rise to the level of first degree murder, deliberate intent, under second degree murder, provocation, all of defendants' arguments come on to that.
You were very slick, I would say, because you didn't answer my question. The jury was instructed that before they consider anything, they have to decide first degree murder. So the question, as I understand it, was they never got to sufficient provocation.
Under the jury instructions, Your Honor, that is correct. If they followed the jury instructions, as soon as they determined that first degree murder was correct, they would have stopped because they did receive that very lengthy instruction, which sort of walks them through how to deliberate. And so then I believe the next step, however, is whether there's sufficient evidence presented as to second degree. And here I believe that there is. And I believe this court can make that decision.
For a jury to decide there is second degree, or believe the defendant say there is not second degree. They're still free to do that.
I didn't follow that question.
Okay. Yeah, there's sufficient evidence for second degree murder, looking at all the evidence in the light most favorable. But the jury could reject that view. A jury could reject that view.
A jury did reject that view.
They never got to there. They never got there. They never considered second degree murder or voluntary manslaughter.
They did not conclude that, Your Honor, but I'm going to actually take a step back in my prior answer. What we know from all of the arguments surrounding the motive instruction is that the jury actually was looking at the difference between first and second degree murder. That is what their question to the court targeted was.
That would require speculation, I think. I think they're asking for this looks inherently ambiguous and inherently contradictory. Please explain. That's all it says. As to why they're sending it, I think would require speculation. I don't like the direct remand rule. Just my questions don't suggest that.
Well, Your Honor, I can't offer an opinion on that.
Okay.
Motive. What is your response that this was either not invited, and I understand the record is awful to put it kindly, And if it was not invited, what prejudice could the defendant argue in this instruction? It seemed to me it's an instruction that's in essence favorable to the defendant's case.
Yes, Your Honor. So first I want to clarify, I believe the state has a different understanding of the record than defendant does.
Okay.
What we have in the record are state's proffered jury instructions, and that's at record proper 271 through 76. And what is not included in the state's proffered instructions is a motive instruction. We also know from the colloquy that occurred over the instructions that defendant proffered 3 instructions and motive was one of them. And so to the extent that those didn't ultimately make it into the record, that is all correct. But I don't think it's a correct statement to say that the record doesn't support that this came from the defendant. And to the extent that it didn't, defendant stipulated to its usage multiple times and did not object. And that's because, also contrary to what defendant has argued to you here today, this did not go to the state's case. The state knew it didn't have to prove motive. Here, the state had to prove deliberate intent, and that is what the state sought to prove. And that's what we argued at directed verdict. That's what we argued in closing. We did not argue motive. In fact, it was the defendant who is using the motive instruction. And I'm sorry, Your Honor, I gave you the wrong citation for the state's jury instructions. I actually don't have that written down. That citation I gave you was actually to defendant's motion to exclude evidence of other crimes, wrongs, or acts. And in that pre-trial motion, what we have is defendant using the motive instruction as part of his theory of the case. Defendant has argued that victim and defendant didn't know each other. So how could it possibly be true that defendant went there to kill the victim? Additionally, defendant has relied on motive in his brief in chief before this court, and that's at brief in chief, page number 14. And so when we're looking at the motive instruction, and I'm running out of time, so I'm actually just going to make it quick and not give you citations. We believe it's invited error, and to the extent it's not invited error, it would be a fundamental error review. And we do not believe that that what occurred here would shock the conscience of the court and that there was not a miscarriage of justice. So we would ask the court to affirm the defendant's convictions and to remand for resentencing on the, I'm over my time.
Thank you,
Thank
counsel.
you.
Owen? 7 minutes.
Few points here, Your Honors. First, the Chavez case that the state pointed to that talked about totality of the circumstances that go to deliberation. There was a lot more evidence presented in that case of motive. I believe there was accomplice testimony in that case. The state there had a very good case of first-degree murder. That is not true here.
So that's similar to how I read Chavez. I did read Chavez differently. As far as a rule, Chavez could suggest this totality. Would you suggest, and I've thought about this, is there a requirement of some kind of hard predicate in which then totality can build around as circumstantial? Or what is missing in this case of Chavez as a matter of rule?
I mean, because sufficiency is so factual, I don't know if an actual rule can be stated, although rules that this court has applied in the past certainly apply, such as bringing a gun alone, for the reasons that Justice Bacon pointed out earlier. Bringing a gun alone is not evidence of deliberation, because this is an open carry, concealed carry, I don't know. It's legal to carry a gun in this state, that I do know. And
So would a rule be something that, trying to pick up on what the chief is thinking about, which is would it be that if you have lots of different facts that give a modicum, a small amount of something that might be deliberation, then that would be the totality that you would look at to reach a conclusion about deliberation? Don't, or maybe a different way of saying this, don't each of the facts that you're relying on have to suggest something about deliberation? It just can't be that fact.
Yes.
So how would we write that? That they all have to relate, at least in some fashion, to deliberation?
That there must be at least some.
I hate the word like some is not a test, so
Yeah,
I get it.
And direct, we can't say direct because the state can prove entirely through circumstantial evidence. But there has to be something that goes even by inference.
And that's what I struggle with. Inference requires something to infer from.
Right.
And it just seems, I'll just hear, I've got a bunch of inferences. I have a lot of totality, but I don't know what I'm inferring from. It seems there should be some requirement that I infer from something.
Well, and this case feels to me like the classic case of stacking inference upon inference, that we don't have any real evidence of what happened that night. And even the state talks about the placement of bullet. Even that doesn't go to level of homicide. Judah testified that he stumbled and shot over his shoulder. We don't know if Samuel turned around during that period. That doesn't really tell us anything. And even if he did actually aim and shoot in the back of his head, do we know why? There still may have been some altercation beforehand that led to that was a heat of passion kind of thing. We don't know that this was deliberate intention here. No matter which way we look at it, there's just no evidence of deliberation. And there has to be, as far as rule.
Our standard of review is the rule.
Yeah, it just,
You look at all the evidence in the light most favorable, et cetera, et cetera, et cetera, and reasonable inferences therefrom. That's the rule, seems to me.
yeah, the way that first degree murder sufficiency cases have been analyzed in the past is that there often seems to be one element pointing to maybe deliberation. So like in Tafoya, this court said, because the state had pointed to that maybe he just did it very quickly. And this court said, well, deliberation can happen in a very short amount of time, but if we're going to find that, there needs to be more evidence that points to that. And there was not that in Tafoya, and this court found second degree murder. And then we have the cases where, similar to this case, the state's only evidence of deliberation is that the defendant took a gun. This court has said, that can be some evidence of deliberation, but there has to be more. So basically, one piece of evidence pointing to possible deliberation just isn't enough. And maybe that's the rule. You have to have more. And that seems to be the way the cases have played out previously. I feel like there was, as far as the ringing in the ear or going deaf from shooting, the state didn't cross Judah on that. Judah testified that he shot over his shoulder. I feel like the state had the opportunity to cross on what impact that had, and it didn't. So I don't think that should play a role in this court's deliberations now. And finally, Judah would ask that this court find insufficient evidence of first degree murder for all the reasons I've talked about, and also find that the motive instruction had a prejudicial impact on Judah's case, and ask this court to remand for a retrial on all the remaining charges.
I do have a question on that on 29 seconds. And you've argued today, and your brief says the parties submitted a packet of instructions, agreed on a packet of instructions that was given to the court. That's tantamount to saying, we agreeing on this packet. So that's the defendant participating and submitting that instruction to the jury. So assuming that's not, that puts you in the position of having to argue, fundamental error.
That's correct. Your Honor.
Thank you, counsel.
Thank you.
I thank both counsel for their papers and oral arguments today in State versus Trujillo. S-1-SC-40328 is under advisement. Court will be in recess till for the call by the clerk.